Good morning, everyone. Welcome to the RTA's webinar about evidence provision for bond claims or disputes and your questions answered. Before we start, the RTA respectfully acknowledges the Aboriginal and Torres Strait Islander peoples as the traditional owners and custodians of this country. We pay our respects to all traditional owners and to their elders, past, present, and future. My name is Cassie Chow, and today I'm joined by Lynn Smith. Good morning, Lynn.
Good morning, Cassie, and good morning, everyone. I'll just introduce myself. So I'm Senior Advisor for the Education and Engagement team at the RTA, and I've been here for over 20 years. Before joining the education role, I was a Senior Conciliator in our Dispute Resolution team, and I've been in the education team now for about 15 years. Prior to joining the RTA, I did work in the private sector, dealing with all the housing legislation across Queensland and New South Wales for over 20 years. So thanks everyone for joining us today, and it's our pleasure to be here.
It certainly is. And to introduce myself, I'm a Senior Community Education Officer. My first role at the RTA was in our contact centre, taking bond and tenancy related inquiries from tenants, property managers, and owners, before moving into our in-house training team as a trainer and coach for our frontline staff, and then into a bit of leadership as well. From there, I've progressed into the education team, and I'm happy to be here and to have all of you here today too. In our webinar today, we'll start by discussing some end of tenancy key points relating to bond refunds, which may assist with the bond refund process to progress as smoothly as possible. We'll then go over the rules for bond claim evidence provision, including the relevant timeframes, examples of supporting evidence, and the difference between the timeline for evidence provision versus the timeline for a notice of claim. Throughout today's presentation, we'll share common questions that the RTA has been asked and that have been raised in our dispute resolution team. If you have any questions of your own, please feel free to place them into the chat, but keep in mind that your questions may be addressed when we go through the common questions throughout today's presentation. And we also acknowledge that while today's audience is mostly managing parties, and that means property owners and managers, we also welcome attendees from the community and tenant sector. Before we start with discussing today's topics, here's a bit of information about the RTA for those of you who are not familiar with us. So we're an independent statutory body and we administer Queensland's rental laws. We don't write the legislation. However, we can and do provide sector insights to the Department of Housing and Public Works, which is responsible for writing the legislation. Our role at the RTA is to help all parties understand their rights and obligations and to provide them with the best opportunity to maintain successful tenancies. So we're here to help everyone involved in a tenancy. Our services include our contact centre, free dispute resolution service, compliance and enforcement activities to uphold and enforce compliance with rental laws, rental bond management, and provision of education through resources such as webinars, podcasts, fact sheets, and our website. We do also work with stakeholder groups such as REIQ, the Property Owners Association, Q Shelter, and Tenants Queensland. Moving on to our information about today's topic, starting with the responsibilities of each party at the end of a tenancy. The legislation outlines responsibilities for both a tenant and a manager or owner at a tenancy's end. For the tenant, responsibilities include cleaning and repairing damage they caused, so the property is left in the same condition as when they moved in, less fair wear and tear, which may be loosely described as wear that occurs due to normal use or changes that occur due to ageing. Paying rent until the end of a notice ending the tenancy or the vacate date, whichever occurs later. Returning all keys and remotes and completing the exit condition report on handover day and providing it to the manager or owner. It's then the manager or owner's responsibility to add their own notes to the exit condition report and return the completed report to the tenant within 3 days. The compliance of all parties with their responsibilities under the Act and within required timeframes may help the process to proceed more smoothly when it comes time to the start of the bond refund. And some other tips include making sure that the tenant is aware of the vacate inspection process, as not every manager or owner is the same, and considering the completion of a vacate inspection together with the tenant. So issues may be able to be fixed on the spot, and options for resolution, including any agreement about the bond refund, can be discussed straight away. So, what does the legislation say about the requirement to provide evidence for bond claims or disputes? Well, in a nutshell, a property manager or owner is required to provide supporting evidence to the tenant within 14 days of making a claim on the bond or disputing the bond. This applies if a non agreed refund is submitted. And what that means is that not all parties have agreed to the bond distribution prior to the bond refund process starting. This requirement does have associated penalties, and therefore failure to comply is an offence, with the maximum penalty equivalent to 20 units. So, the Residential Tenancies and Rooming Accommodation Act doesn't provide a specific definition of supporting evidence. However, it does provide examples, which are receipts, quotes to repair damage, and records of unpaid rent. Now, you'll notice that these examples are all financial in nature. Okay, so let's talk about some common questions that we get asked, and I'm going to invite Lynn back to help with this now.
Thanks, Cassie, and thanks. We do have a couple other questions coming in, which we'll get to at the end as well.
Mhm.
Okay, first question that we're commonly receiving is what does count as evidence, Cassie?
The Act doesn't provide a definition of evidence, but it does provide three examples, and those were receipts, quotes to repair damage, and records of unpaid rent.
So a lot of it is really around that monetary evidence, really, isn't
Yes,
it?
that's right.
Next question. Does evidence have to be invoices, or if I'm claiming for damage, can it be an exit condition report with photos?
Okay, so that's a good question, and similar scenarios have often been presented to us after our in-person events. While the RTA can't make a decision about what does or does not count as evidence, we mentioned previously that the Act provides examples, so we've mentioned that a couple of times, and they're all financial in nature, as we've discussed. The examples provided help to support the amount being claimed from the bond, so that's why they're financial in nature. Now, for example, um, say that you as a property manager or owner are claiming $550. The reason being property damage, because it's going to cost $550 to do repairs. So the evidence that you provide to the tenant needs to substantiate that $550. Or as another example, you are claiming $50 to clean the oven because the tenant didn't return it in the same condition as when they moved in. Um, and you need to provide evidence to show that that's how much the cleaner is charging to clean the oven. And similar to with claims for a dirty property, we get asked this question as well. Show that you're claiming a particular amount because that's how much it will actually cost to get a cleaner in.
Right. Thanks, Cassie. Now, the next one we know because we have been, excuse me, traveling around Queensland a fair bit in the last few months, and more so in the regional areas. So, the next question, if you put up, Cassie, is when there's a shortage of tradespeople at the moment, how are we expected to get a tradie in attendance and provide the quotes within the 14 days?
Mhm. So this is, a situation that can get tricky, and providing evidence might require some thinking outside the box. So some options for this scenario might be, say, sending a photo to a tradie to see if they can give you an estimate rather than them coming to the property. And that was actually something that was shared by a property manager at one of our information sessions. Another example might be using a quote for similar damage that's recently been repaired at another property. and you provide that quote as evidence with, of course, the personal details of any other person redacted. Or a third example might be trying a different tradie if you have a usual one that you use, but they're not available.
Excellent. Thanks, Cassie. Now, the next one, which probably will answer a couple of questions that we've actually already got submitted as well. If I do the work myself, can I submit my own invoices as evidence?
Mm-hmm. And that's an interesting question. Firstly, just note that the RTA can't give legal advice, but invoices would usually have an ABN or they're a taxable invoice. So you would need to demonstrate how or why the amount is calculated, and again, consider advice about whether this would be acceptable in QCAT.
Because ultimately, it's QCAT that would make a decision whether that would be an acceptable invoice or not.
That's right.
And our last question on that we've got here, if I've tried to obtain evidence, but I haven't been able to, do I still need to provide it?
Well, the Act doesn't make exceptions to the requirement for evidence provision. So if you can't obtain evidence, you might try contacting the tenant with evidence of your attempts at obtaining evidence to support your bond claim. But yes, tricky one.
Awesome. Back over to you. Thanks.
Thanks, Lynn. Okay, so legislation relating to bond refund evidence provision does also specify that a manager or owner must make reasonable efforts to contact a tenant within 14 days of a bond claim or dispute to provide the supporting evidence. Under the Act, reasonable efforts include telephone, text message, email, private message on a social media platform, and via the emergency contact on the tenancy agreement, which you can see listed on the slide. If contact attempts aren't successful, then the requirement to provide evidence does not apply. However, we'd like to note and emphasise that you should have the evidence before you attempt contact. And we would also encourage you to make sure you have the tenant's up-to-date contact information and to document your attempts at contact. We would highlight too that since the emergency contact is listed as part of reasonable efforts to make contact, you may want to encourage the tenant to include these details on the tenancy agreement. Now, a quick slide here to illustrate the difference between the timeline for evidence provision and the notice of claim, which are two separate processes and should therefore be considered on their own. Now, just note that the diagrams on the slide illustrate the timelines for a bond refund request submitted via paper form, which doesn't have a fast track period occurring before the notice of claim, like an online refund request does. So you will see on the left-hand side that when a managing party submits the bond refund, then the 14-day time frame for providing evidence starts at the same time as a notice of claim. However, when a tenant submits the bond refund request, then the two timeframes may start on different dates. So the 14 days for evidence provision would begin when the managing party disputes the bond refund. Okay, Lynn, what are some more common questions that we get asked in this space?
Okay, what can I do if there's a disagreement about whether evidence has been provided?
Okay, so we've been hearing from our dispute resolution team that this has been occurring. Some resolution options may include sharing documentation with each other. So, for example, if you're a managing party and you sent your evidence via email, then provide evidence of the email showing that when it was sent and what time it was sent. Or apply for dispute resolution to help you reach a resolution if that doesn't help. Um, for the managers and owners out there, also keep records of your attempts to contact the tenant to provide evidence.
Excellent. Thanks, Cass. Next one is what can I do if my original claim or dispute amount is different to what I end up needing to claim? And we know that this sometimes does happen.
Mm,
That there might be like an estimate, and it may actually need to be changed because it's a little bit less, or maybe around not quite the
yeah.
exact dollars.
Yes, that's right. We have heard of this happening when, say, a bond refund is submitted prior to the vacate inspection being completed, or when the tenant makes a bond refund request and it's then disputed and the amount needing to be claimed changes. So in this type of situation, it's important to communicate with each other in a timely manner and just to work together. We talk about this a lot, that resolution works better when you all communicate and work together on a resolution. So you could try to come to an agreement prior to the bond refund request being submitted, just to help mitigate that scenario happening. Um, and this means that you could submit a fully agreed refund, like we were talking about a couple of minutes ago.
Mm.
Try to complete your vacate inspection before the bond refund process is started, if you can, and communicate with the tenant about this. So issues can be identified then and resolved at that time. And in this way, there's less likely to be a need to dispute or pause the bond refund. And also, and I think importantly, use your past experience to estimate how much it may cost if you know that you need to make a claim. And I'll give you an example here. So if you know that you may need to get a cleaner in, and recent experience indicates that this may cost, say, anywhere between $300 and $500, then perhaps make a claim for $500 to $600 and then release the rest of the bond back to the tenant.
Awesome. Now, our next question, Cassie. Now, I'm a tenant and I don't believe that the evidence I've been provided is suitable. Can the RTA tell me whether it is or is not suitable?
Hey, good question. And well, the RTA can't make decisions about whether a piece of evidence provided is suitable or not. It's not part of our role. So if the parties are in dispute and they haven't been able to self-resolve by communicating with each other, then the RTA's dispute resolution team may be able to assist, and they'll help to facilitate the discussions. And if it's not successful, then an application may be made to QCAT, that's the Queensland Civil and Administrative Tribunal, for a ruling. And it's only a QCAT adjudicator that could ultimately make that decision.
Great. Thanks, Cassie. Our next one, this is something that we are hearing in our dispute area as well, is
Mhm.
what happens if a managing party does not provide evidence within the 14 days? Now, we are dealing with a non-agreed refund form, aren't we, when we talk about the evidence, correct?
Correct. Yes. Yes. Well, the requirement to provide evidence to a tenant is it's required under the law, and failure to comply is an offence, which we mentioned earlier, with a maximum
Mm.
of 20 penalty units. And for everyone's awareness, the value of one penalty unit is $166.90. And that means that the tenant may be able to request an RTA investigation into non-compliance with this requirement.
Great, thanks, Cassie. Our last one that we know that we are receiving is, can I submit a request for investigation if I don't think my managing party has provided acceptable evidence?
Okay, so the offence provision that we've been talking about from the Act relates to the provision of evidence within the 14 days. It doesn't relate to whether the evidence provided is appropriate or not. And as we've discussed earlier, if parties are unable to resolve disputes about the evidence between themselves or with the help of our dispute resolution team, then an application may be made to QCAT for a decision by an adjudicator.
Awesome. Thanks, Cassie. We'll come back. We've got a lot of questions. So we'll just add one more before we do go, because there are a couple of people just asking, well, what happens if the cost to rectify the damage to the property is greater than the bond? Now, that would be that they can still come through the RTA's dispute resolution process once the bond's been paid out and then pursue the matter through QCAT. Correct, Cassie?
Yes, that's right.
Fantastic. Thanks, Cassie. Over to you.
Thank you, Lynn. Um, so to help all of our customers, the RTA does have some information about today's topic in a variety of formats on our website. On our bond refunds webpage, which Lynn posted a link to earlier, you will find a section that outlines the requirements relating to bond claim evidence provision. And on the ongoing rental law changes frequently asked questions page, that's a bit of a mouthful, you'll find a number of relevant frequently asked questions as well. In January of 2025, we published a podcast about this topic, which provides an overview of the legislation and does discuss a couple of scenarios. And now, just a reminder that the RTA is here to help you. Make sure to follow us on Instagram and YouTube and to subscribe to our Talking Tenancies podcast and e-news. For those of you who use social media, just want to highlight that the RTA has a page on Instagram and you can find it using the handle at rta.qld. And we're also on LinkedIn. Now, if you would like information relating to a specific situation that you're in, please also remember that our contact centre is available on weekdays between 8:30 a.m. and 5 p.m. and our friendly team there can assist you. And that concludes our presentation for today. And thank you to everyone for joining us. And thank you again, Lynn.
Thanks, Cassie. It's been a pleasure, and thanks everyone for coming today.
Yeah, we look forward to seeing you at one of our free information sessions or webinars across the coming months. And this webinar will now close.